Welcome back to this third segment of this law session on precedent. Immediately before the break, of course, we were looking at overruling, and then we were also looking at reversing. I said we would carry on, and without much further ado, of course, we will. I was explaining as it related to overruling, and I did want to finish off by saying that when you look at reversing, this is the overturning on appeal by a higher court of a decision of the court below who had heard that appeal. Now, the appeal court will then substitute its own decision, and this can only be carried out by a court with enough authority, such as, for example, the Divisional Court, Court of Appeal, or indeed the Supreme Court. Most cases, as I was saying before, will stop at the Court of Appeal level. They do not tend to go on to the Supreme Court. Now, when you look at the case of Crown and Kingston in 94, the House of Lords reversed the decision of the Court of Appeal and held that involuntary intoxication will not be a defense unless it prevents the defendant forming mens rea for the crime charged, even though the defendant was not at fault for becoming intoxicated. That is how you see reversing of a decision in practice. All right, let's turn our attentions to something that ranks rather importantly in the context of precedent. It's law reporting. Because in order for the doctrine of precedent to operate and expand, an efficient system of law reporting is practically mandatory. Now, if you look at the background to law reporting, you see that from 1535 to around 1865, cases were reported by individuals who would then sell these to lawyers, but the accuracy sometimes varied from one reporter to another reporter. Now, I'll give you a for example. You will have done, of course, in contract law, the case of Williams and Ruffy. Now, in the case of Williams and Ruffy, we see that there is a discussion of the old case of Stilk and Merrick. Now, in the case of Stilk and Merrick, we see that there is this issue about consideration and whether you're looking at it from a public policy standpoint, so in the context of whether you will not allow, for example, seamen on the high seas to hold a captain to ransom, or you're looking at whether there was no consideration. Now, in the case of Stilk, there were two reports. There was the Espinas report, and there was a Campbell's report. Now, both of these law reporters, in their report, gave a different approach to what the court found as the basis in respect of why they didn't get relief. One of the reports said that it was because of public policy. The other report said that it was because there was no consideration. The point being that when you look at the system of law reporting up to 1865, we get a situation where individuals are doing the reporting and the accuracy can therefore be compromised. When you look also at the Incorporated Council of Law Reporting, this was set up in 1865, it's controlled by the courts, and it produces the official law reports, which are written, of course, by trained barristers and lawyers and so on. There are other reports which include the All England Law Reports, published by Butterworths and the Times Law Reports. Law reports are now available online, for example, the Court Service website, as well as Bailey, B-A-I-L-L-I, British and Irish Law Incorporated. You look at B-A-I-L-I-I is the free. Bailey.org is the website for the free, where you can get cases free. Now, when you consider precedent, we generally know that it is the system of law reporting, the adherence to the hierarchy of the courts, that is important. But what about persuasive precedent? A persuasive precedent is one which is not absolutely binding on a court, but which may be applied. So things like a decision of a court which is lower in the hierarchy. So the House of Lords may look at something said at a court of appeal level. So for example, when you look at the case of R&R, the marital rape case, where we see the House of Lords following the decision of the Court of Appeal and saying that the husband was liable. When you look again at decisions of the Judicial Committee of the Privy Council, for example, that may be where, one, it's persuasive precedent, but it may just transcend that boundary of being the actual authority. One I'm thinking of is the Wagon Mound in 1961, which is the leading authority on remoteness of damage in the tort of negligence, and it was an Australian case, of course. Decisions of the courts in Scotland, Ireland, the Commonwealth, so particularly cases from Australia, Canada, New Zealand, and sometimes even the US. These are usually cited where there is a shortage or a complete lack of English authority on the actual point. So for example, in the case of Ray S. or Re S., which was about an adult and it was to do with the refusal of medical treatment, the courts looked at other jurisdictions. The obiter dicta of English judges, remember I say obiter dicta is by the way, so it's not the ratio of the case, but it may later on come to be, for example, the point that the courts look to. And what I'm thinking of the top of my head, for example, is when we look at this idea for example, it's a tort principle, but when you look at the idea of there being liability for negligent misstatements, we see that in 1952, Lord Denning, in his obiter remarks, said that he did not see why there was a reason that liability is not attached where, for example, somebody makes a statement negligently which caused loss. Because he said, when you look at, for example, words, it has a far wider reach than even actions. Now, when we look at the case of Hedley, Byrne and Heller, we see those remarks coming on board. And in fact, when you look at the principle in Hedley, Byrne and Heller, it's actually obiter, but it stands for that principle that where you're looking at a negligent misstatement, then liability can attach. What then are the advantages of precedent? Well, there is certainty in the law. You look at an existing precedent, you can tell what's going to happen. There's uniformity in the law. Like cases followed like. There is flexibility in the law. You're able to maneuver it. It also is practical, based on real facts, which is not like legislation. It is also detailed. You can look at the cases and see how the courts came to their decisions. But for what is its virtue is also its vices. So when you look at the disadvantages of precedent, for example, precisely because it is so detailed sometimes, you don't know what is the ratio. You can have 3 judges, 5 judges. They all came to the same conclusion, but all of them have said something different. So difficulties can arise in deciding what is the ratio decidendi, particularly if there are a number of reasons. Also, there may be a considerable wait for a case to come to court for the point to be decided. The devices to get around it, for example, distinguishing and overruling, may also mean that you can't rely on it. Equally, it may be complex and voluminous precisely because you're dealing with lots and lots and lots of cases. So that may be a problem. It is somewhat rigid as well, as you have to follow the higher courts. But frankly, sometimes when you look at the cases, it goes to the trial court. The trial court finds for X, the plaintiff. It goes to the Court of Appeal. Court of Appeal finds for Y, the defendant. It goes to the House of Lords, and the House of Lords agrees with the trial judge. So sometimes you go through these protracted proceedings only to come back to the first instance decision. Sometimes the distinctions can be completely illogical, especially when you're looking at how, for example, the judges look at the cases. It may appear logical because they want to, of course, find for what looks like fairness. Now then, we know the hierarchy. We know the courts. We know what the process is. What then is the judge's role in precedent? Well, the old view of the judge's role was that they were merely declaring the existing law. So what is known as the declaratory theory. Now, Lord Esher, in Willis and Badley in 1892 said, there is no such thing as judge-made law, for the judges do not make the law, though they frequently have to apply existing law to circumstances as to which it has not previously been authoritatively laid down that such law is applicable. Well, when we look at the modern view is that judges do make law. And the idea is that maybe you need to look at Lord Radcliffe in his book Not in Featherbeds, which is written in 1968. He said, there was never a more sterile controversy than that upon the question of whether a judge makes law. Of course he does. How can he help it? Now, the reality, of course, is that judges are continually applying the existing rules to new facts and situations and thus creating new laws. I am going to break there for a moment, and when we come back, we're going to finish up with looking at how the judges have approached this, and we will also, of course, look at the Supreme Court in this framework.